Right. So I see we've got a number of folks here on the meeting, which is wonderful. I'd love to invite you all to go ahead and put in the chat the county that you're from, as well as your role. I love to know who I'm presenting to, especially when we're in a virtual space like this, just so I have a sense of what your role is and how to best speak to the fair housing information that you need. So I'll give you all a moment to go ahead and start putting that in the chat. All right, thanks for those responses so far. Looks like we're seeing a couple different counties represented. All right. Right, great to see that we've got representation from across the state. So today, I want you to feel free to voice questions that you have. Go ahead and put them in the chat. Raise your hand if you have a question. I want to make sure that I'm providing the fair housing information that you're looking for this morning. But I'd like to ask you one more question before we get started. I'd love to see how many folks have had fair housing training in the past. So could you raise your hand if you've received fair housing information in the past? Right, it looks like a substantial number of folks have received training in the past, which is great. We recommend having regular training just so this is top of mind and you can keep up to date with any updates. So hopefully this will be a good refresher for most folks. And some great information for folks who haven't been exposed to this information before. So we're here because it's the right of all Pennsylvanians to have fair housing, housing that meets their needs, that's free from discrimination, that includes housing that is safe and affordable and in an area of their choosing. So why is this so important? As folks that are working in housing, you know that where we live and the housing that we can access impacts so many other areas of our lives. Our employment, our educational opportunities, and the quality and availability of public services and amenities, and things that are important to our health and safety. So as I'll mention later on, the Fair Housing Act has two main goals. So preventing acts of discrimination and working towards more equitable communities. So you all were invited to this training because in all of our various roles, we all have a role to play in eliminating barriers to fair housing choices. And we believe that the work of fair housing starts by learning and engaging. So thank you all for being here this morning. I've got a substantial amount of information to cover in the presentation today. I don't expect you to remember it all off the top of your heads or to take notes the entire time. Please rest assured that we'll send out these slides afterwards so you have all of this information as well. So our training today is going to cover the basics of housing discrimination in Pennsylvania. As David mentioned, there's a follow-up training that's going to happen next month that'll be provided by PHRC's Director of Fair Housing and Commercial Properties. That's going to delve into a deeper dive into some of the systemic issues in our housing systems. So how they came about, what tools are available through fair housing laws, and how you can work in your communities to minimize barriers to equitable housing. But today we're going to start by laying some groundwork. So that way you have a good sense of what protections your community members have, how they can access remedies, and what housing providers' responsibilities are in protecting fair housing rights. So starting off with who the Human Relations Commission is, our relevant fair housing laws. We'll cover protected classes and discriminatory practices. We'll do a deeper dive into reasonable accommodations and modifications for individuals with disabilities, since that's a big area of focus and a big area of of complaints that are received, and then we'll have time to answer your fair housing questions. So I will pause for questions throughout the presentation, monitor the chat regularly, so that way we're making sure to answer the questions that you have. So who is the Human Relations Commission? We use the acronym PHRC, so you'll hear that throughout the presentation. Our mission takes two parts. The first one, the one that we're most well known for, I would argue, is enforcing our non-discrimination laws that we have on the books in Pennsylvania. So there's the Pennsylvania Human Relations Act, as well as the Fair Educational Opportunities Act. So we've been around since 1955. We investigate allegations of illegal discrimination, and we work to facilitate settlements between parties. The second part of our mission is to promote equal opportunity for all in Pennsylvania. So we do this through a variety of partnerships. So there's a task force that addresses issues of civil tension, and that is in partnership with the Attorney General's office, with the state police, with other local, state, and federal partners. We have advisory councils in communities throughout the state of Pennsylvania. You can see the counties listed on the screen. These are groups of volunteers that work to get information about individual civil rights out into the communities, put on trainings and events, and help people understand the complaint process and how to access assistance when they're experiencing civil rights issues. We work with our local human relations commissions to share information, provide training. We're a part of the Affirmatively Furthering Fair Housing Task Force, working throughout the state to support housing opportunities. And we also work with various fair housing and advocacy organizations. A big part of my role is providing training. So we have a wide variety of audiences. We're in schools, workplaces. We work with community organizations, housing providers, local officials, and community leaders. We've got a whole list of trainings which are available on our website, but you can also feel free to just reach out to me if you've got some a fair housing topic that you'd like training on for your team or for a specific group within your community. We're happy to provide that training, and we do that free of charge. So at PHRC, we've got 3 different regions. Our Western region is served by our Pittsburgh office. Our Central region, which reaches up into the northeastern part of the state as well, that's served by our Harrisburg office. And then the southeastern region of the state is served by our Philadelphia office. In addition, we've got a central office that serves the whole state with more administrative and executive tasks, and I'm part of that group serving the whole state. So what do the laws that I mentioned earlier cover? So they cover employment for organizations that have 4 or more employees, for housing. That covers folks that are looking to rent, lease, buy, mortgage, provide modifications on a home. That's where our focus is going to be today, since we're talking about fair housing fundamentals. For commercial properties, it's very similar to housing, but that's if someone's intending to develop or put a business into a property. When we talk about public accommodations, that's any place that serves the general public, such as a restaurant, store, pools, public schools, and it covers accessibility. And when we talk about protections in education, that's all the way from elementary to post-secondary education. But let's delve into fair housing laws. There is a pretty wide variety of laws and at different levels. So the one that most folks are familiar with is the Federal Fair Housing Act. but they're at the federal level. There's also Section 504 of the Rehabilitation Act of 1973, as well as the Americans with Disabilities Act. As I mentioned earlier, at the state level, we've got the Pennsylvania Human Relations Act. And then in many communities throughout the state, there's additional ordinances which offer even greater protections. So there are roughly 70 different ordinances throughout the state of Pennsylvania. So I'd love to invite you to raise your hand if you're aware that you have a local ordinance that provides additional fair housing rights in your community. I'll pause just a minute to let folks raise their hands. All right. Seeing a couple hands raised, which is great. If you're unsure if you have a local ordinance, check in with your local leaders, and they should be able to provide you that information. And you can also reach out to the PHRC. We can also let you know, since we keep in contact with a lot of those commissions and councils that enforce those ordinances. Okay, so what do fair housing laws cover? They cover both the sale and the rental of housing, as well as housing-related services. So when we talk about services, we're talking about mortgages, lending, insurance, appraisals, any of those professions and services that would impact someone's housing. There are two different types of housing discrimination, and we'll talk about each one of those in a little bit more detail. But the first one is disparate treatment. So that's treatment that directly discriminates against someone because they're a member of a protected class. So telling someone that they're not going to rent to them because they don't want someone of their religion in this neighborhood. That would be disparate treatment. Disparate impact would be a policy that appears to be neutral on its face, doesn't reference any protected classes, would seem to apply to all residents, potential residents, home buyers, but it's got an impact that's greater on members of a protected class than other individuals. So we'll talk about criminal background checks a little bit later in the presentation, but they're a great example of a disparate impact issue. If a housing provider has a blanket ban on criminal backgrounds, which means that no one with a criminal background would be allowed to live at that property, that would have a disparate impact on people of color, because we know that people of color are disproportionately represented in our criminal justice system and are more likely to have charges on their background. So that's why HUD has some guidance for housing providers on how to handle these screenings. I'll get into that in a little bit more detail later. But the Federal Fair Housing Act, which I mentioned earlier, it has two goals. It aims to end housing discrimination and to promote diverse, inclusive communities. And then the second goal would be affirmatively furthering fair housing. We call that AFFH for short, since it's a bit of a mouthful. And it really embodies the values of fair access and equal opportunity, helping to make all neighborhoods places of opportunity by providing their residents with access to the community assets and resources that all community members need to flourish. So the language that's used in the Fair Housing Act is taking meaningful actions in addition to combating discrimination that overcome patterns of segregation and foster inclusive communities free from barriers that restrict access to opportunity based on protected characteristics. So when we receive a complaint of housing discrimination at PHRC, we make sure that it's jurisdictional. And jurisdiction looks a little bit different at the state level and at the federal level. So the U.S. Department of Housing and Urban Development, HUD, under the Fair Housing Act, if a housing provider doesn't receive federal funding, doesn't publicly advertise any vacancies, then a housing provider is obligated to comply with fair housing laws if they have 4 or more properties. However, if they do receive federal funding, if they do publicly advertise when they've got vacancies at their properties, then even if they only have 1 or 2 or 3 properties, they still must abide by fair housing laws. At the state level, under the Pennsylvania Human Relations Act, housing providers are required to comply with our laws, even if they only have 1 property, regardless of the funding or advertising. So you can file at the Pennsylvania Human Relations Commission up to 180 days after the date of the last harm. You can reach out and file a complaint with us. HUD has a little bit longer of leeway. You can file up to a year after the date of the last harm or the date of the last instance of discrimination to file a complaint with HUD. If you would contact PHRC after that 180 days, we would refer you over to HUD, so that way your complaint can still get investigated. But any complaints that are eligible for dual filing will be dual filed with HUD and jointly investigated. So I mentioned protected classes earlier. So I want to have some discussion around what classes are protected. What is a protected class? It refers to a characteristic or a trait about someone that cannot be taken into consideration when they're engaging in housing transactions. So why do we establish these? It's because the things that you see on the screen here have nothing to do with how successful someone will be in their housing or in paying their mortgage. And it's unfair for people to be treated differently based on these characteristics. So you'll see a number of different classes listed on the screen here. There are 7 at the federal level under the Fair Housing Act and related amendments that have been added over time. Race, color, sex, religion, national origin, familial status, and disability are all protected classes at the federal level. Retaliation is also protected against. So if someone would file a fair housing complaint and then their housing provider would retaliate and take retaliatory actions against them, that individual would be protected by the Fair Housing Act, and they could actually file a second separate complaint under retaliation. There are additional protections at the state level. So that includes specifically the use, handling, or training of support animals for disability. So under the Federal Fair Housing Act, support animals are covered, but they're specifically for the individuals with a disability. Under the Human Relations Act, it also includes the folks that do the handling and training, even if they don't have disabilities themselves. Ancestry is also covered under the Human Relations Act, as well as age 40 and above. So I mentioned the local human relations ordinances earlier because they may have additional protected classes in your area that would provide additional protections for individuals beyond what's covered at the state and the local level. So I want to talk a little bit more about a couple of these protected classes in detail. So I'll be talking about familial status. I'll be talking about age, and I'll be talking about sex before we move on to talk about discriminatory acts. So I see there's a question in the chat if citizenship is considered a protected class. So it's not specifically a protected class, but it would it could be tied in with national origin. So if someone was born in another country, that citizenship, if their housing provider is taking discriminatory actions against them because of their citizenship, it's possible that they could file a complaint under national origin. Give me just a moment to take another look at the chat, see if there's any additional questions that should be answered before we move on. not seeing anything at the moment, but please feel free to enter any questions or comments that you have. All right, so let's talk about familial status. This includes a couple different groups of people. So this includes families with children under the age of 18 who are living with their parents or legal custodians. It includes people who are pregnant. And it also includes people that are securing children, custody of children under the age of 18, which includes foster children as well. HUD did a survey a couple of years ago and found that 38% of people who were surveyed didn't know that families are legally protected from discrimination. So it's something that I try to highlight in my presentations. So a housing provider could not refuse to rent or lease to a family because their children, couldn't specify specific areas or units that families live in, and they can't impose different terms or conditions for that housing simply because there's children or pregnant folks living in that household. There is one exemption to that, and that's related to age. So there are specific communities that are designated for either 55 and over or 62 and over. So families can be denied housing in these communities if they don't meet the requirements that are listed on the screen here. So 55 and over, it's a little bit more flexible. So at least 80% of these units have to be occupied by at least one person who is 55 and older. In order for this community to maintain their status, they must advertise and market as being 55 and older. Only one resident needs to be 55 or older in this community or in each unit. However, age limitations can be placed on other tenants provided they're done so in a consistent manner, and they can deny residency and access to facilities and services to children and those under 55, but they do need to be consistent in their application of the rules. 62 and over communities are a little bit stricter, so they do have to have a certification by the government. Everyone in these communities must be at least age 62 to live there or older, and no one under age 62 is permitted. So obviously you're not going to be able to have families with kids that live in these communities. All right, I want to talk about sex as a protected class under the Human Relations Act. So you didn't see on my list of protected classes, you didn't see sexual orientation, gender identity, any of these other categories that you see on the screen here as specific protected classes because they aren't protected classes under the Human Relations Ordinance or under the Fair Housing Act. However, in 2018, the Human Relations Commission issued some guidance, and that states that the term sex may refer to sex assigned at birth, sexual orientation, transgender identity, gender transition, gender identity, and or gender expression. So it's pretty expansive. And you can find that specific guidance listed on our website if you want to read some more information. So we use this guidance as we accept complaints, as we conduct investigations, and as we adjudicate cases. So accepting when the Commission accepts a sex discrimination complaint that arises out of any of these different categories, it doesn't necessarily state that that there's going to be a finding of probable cause of discrimination or that that the actions were definitively unlawful. The investigation has to take place, but it does allow us flexibility to accept those complaints. At this point, the guidance is not statute or regulation, but it is instructive for us as each case is processed on a case-by-case basis. And as of April, we proposed regulations to further solidify these protections into a regulation. So you can see the link on there for some frequently asked questions, as well as the regulation itself. It's currently in process, working through the regulation process at the IRRC, and we're hoping that that gets finalized in the near future. All right, I think I saw some questions in the chat, so I want to take a moment to address those before we move on to discriminatory practices. There was a question: if a person claims they were discriminated against in July of one year and didn't file a complaint until February of the next year, that I believe that would be 7 months if my math is correct. So PHRC would not be able to take the case, but that individual would be able to file with HUD and have it investigated at the federal level. So they would still have those protections. Now, if this discrimination was ongoing, if it wasn't one discrete event, but they continued to experience discriminatory acts of harm, that clock would kind of reset as of the date of the last harm. So that should be taken into consideration as someone's looking at where they can file. All right, I see a question on occupancy limits. So a family, if you only have a 2-bedroom apartment and a family of 5 or above, applies for housing, and there's a local ordinance that maximizes the amount of people per bedroom. Occupancy limits are something that do come up, particularly in terms of familial status. So if there is a local ordinance that often it's a 2 people per bedroom ordinance, you would need to abide by those local ordinances. If there isn't that type of ordinance in place, or if it's based on square footage, then I would encourage you to look at a document that HUD put out called the Keating Memo. So that states that 2 people per bedroom is a pretty good standard, but you should make sure that you're taking into consideration other factors of the unit. So say there might be an extra den or a really large bedroom that could accommodate more people. You should be flexible and take a look at the features of the unit before automatically denying someone a family housing because they might have one additional person above that 2 people per bedroom standard. So that is a familial status issue because that's something that would have a disparate impact on families with children in comparison to the general population. So I hope that answers your question. Yes, so retaliation is protected under the Federal Fair Housing Act as well, in addition to the Pennsylvania Human Relations Act. All right, so let's move on to discriminatory acts. Excuse me one moment. Okay. All right, so the first discriminatory act that I want to highlight is discriminatory statements. So this would be printing or circulating statements that indicate a preference or limitation that's related to a protected class.
Hey, Brittany.
Yeah.
Your PowerPoint went away.
Oh, thank you for letting me know that. Let me see. Are you seeing my slides right now? Let me get it for a second. All right, are you seeing my slides right now? Okay, great. Thanks for that confirmation. All right, so discriminatory statements. That's printing or circulating statements that would indicate a preference or limitation related to a protected class. So this is not just limited to print advertisements in newspapers. It could be advertisements on a company website, social media, Facebook Marketplace, Craigslist, PadMapper, or wherever housing is being advertised. So examples of statements that you would want to avoid would be near a Catholic school, perfect for empty nesters, near a Korean grocery, or great for singles, because you want to make sure that you're not intentionally or inadvertently making any comments that would make folks feel unwelcome due to their protected class. There are a list of words that could possibly violate advertising provisions of the Human Relations Act. So we encourage all housing providers to avoid any of these words. The one exception would be for housing for older persons, in which case you would be able to use a couple of these words. So, and on the next screen, you'll see there's a list of words and phrases that do violate the advertising provisions of the Pennsylvania Human Relations Act. So definitely don't use these words. These are unlawful. The only reason why you would want or be able to use these is if there's an owner-occupied building that you're advertising. So a good way that I'd like to think about this is making sure that you're describing the features and characteristics of the unit itself, not characteristics of the inhabitants that you think might be a good fit for it or you think might want to live there. You want to make sure that any advertisements make all prospective tenants feel like they would be welcome to the property. All right, the next discriminatory act that we want to make sure that everyone avoids is refusing to sell, lease, finance, or otherwise withhold housing or commercial properties because of a protected class. So this is kind of the standard that a lot of people think about when they think about fair housing violations. So a realtor that would refuse to show homes to a Latino couple because the seller knows that neighbors don't want these kind of people in their neighborhood. Or a bank refusing to lend money to a pregnant woman because she can't prove that she's going to go back to work once the baby is born. So that would be an issue on the protected class of sex as well as familial status. And falsely stating that a property or a unit is not available when it actually is in fact available, just because the landlord doesn't like the religion of the potential tenant. So all of these things would be unlawful under our fair housing protections. Next up, we've got discriminatory terms or conditions. So still, in this case, someone would still be provided the housing, but the terms or conditions with that housing, whether you're selling, leasing, or financing, are impacted due to a protected class. So an example of this would be higher fees if there's teenagers in the family, an extra security deposit for service and support animals, because that would have a disparate impact on individuals with a disability, as well as increased monthly rental costs for folks of different races. You want to make sure that any kind of fees, deposits, lease provisions, they are done equally for all individuals, regardless of protected classes. In addition, you want to make sure that the facilities, the services, and the privileges that are connected with the property are provided equally as well. So we hear about this with familial status, not allowing children to use the pool or the gym facilities, other facilities throughout a complex. Could be ignoring or taking longer to complete maintenance requests based on someone's protected class, not based on the procedure in place when it was received and the nature of the request. And lastly, if there's an unequal application of rules and lease provisions. So say you would have women held to a higher standard than men in terms of whether it's guest policy, quiet hours, things like that. You want to make sure that if you're enforcing these lease provisions, if you're issuing lease violation notices, that you're doing it equally and according to the procedures that you have laid out, not because of anyone's protected classes. All right, so a housing provider cannot make an inquiry or a record related to a protected class in the process of selling, leasing, or financing housing. So this could look like asking if someone has a disability on a mortgage application, or asking a caller who's inquiring about an apartment for their race, or if they have children. You want to make sure that the protected classes don't play a factor in any decision-making about selling, leasing, or financing housing. So there really isn't any reason to be collecting this information aside from if it's a federal program that requires you to collect this demographic information for reporting purposes and not for any decision-making purposes. You want to steer clear of steering. So this would be attempting to induce listing, sale, or other transaction, discouraging someone from purchasing or leasing by talking about either directly or indirectly who's in the neighborhood, who used to be in the neighborhood, who may be in the neighborhood in the future, specifically regarding protected classes. So there was a report that was released a couple of years ago, Long Island Divided, in which Newsday looked into steering using some testing practices, and they found some pretty dramatic results in terms of differences in services provided for homebuyers based on their race and ethnicity. They found that different groups were provided more or less listings based on their race and ethnicities, were given listings in different neighborhoods with white residents or with white home buyers steered more towards white neighborhoods, and people of color steered towards neighborhoods where there were already more individuals and families of color living, and providing different information, tips and heads up about safety and schools and things like that. All of this can lead to different home buyers and renters being directed towards different types of housing. And it's important that everyone have equal access to all the housing opportunities that are available and in their price range. Another discriminatory practice would be sexual harassment, which would be harassment based on sex. So when we talk about sexual harassment, there's two main types. The first one is known as quid pro quo. So that would be when a housing provider subjects someone to an unwelcome request or demand for sex or sexual favors, and they would need to comply as a condition of getting housing, maintaining their housing, getting maintenance, or other services. On the other hand, there's a hostile environment, in which case there might not be a specific request for sex or sexual favors, but someone's subject to unwelcome conduct that's either sufficiently severe or pervasive and occurs repetitively to the extent that it interferes with and deprives a tenant of their right to use and enjoy their housing. So this harassment could be physical, it could be verbal in the comments or jokes, name calling, it could be visual in pictures that are shared, it could be in written text, notes, emails, social media. Harassment can be sexual in nature. It can also be non-sexual in nature. There could be harassment based on another protected class, which is also prohibited under fair housing protections. So if you're in a position where you own or you manage housing, you want to make sure that all of your staff and your vendors are trained on harassment, what it is, how to make sure that you're steering clear of that, and have a good understanding of fair housing laws to make sure that no one on your staff, from your property managers all the way down to your maintenance staff and outside contractors, are engaging in any actions that could be construed as harassment. And if there would be an incident reported, you want to make sure that you're taking immediate actions and that you're documenting that very clearly. All right, so the lending industry must abide by fair housing protections as well. So lenders need to make sure that they are not targeting people for unfair or deceptive loans based on protected factors such as race, sex, or age. Back in 2012, there was a settlement of $175 million lawsuit that included 8 states. $3.4 million of that was for reverse redlining in Philadelphia, in which neighborhoods of color and folks that are receiving lending services were targeted with riskier lending products, more expensive lending products. And that was done unfairly based on race and ethnicity. I touched on this a little bit earlier in the presentation, but housing providers should be cautious about their use of criminal history. So in 2016, HUD issued some guidance stating that a landlord or property manager is required to consider a person in their entirety, not solely using criminal history as a screening factor. So this means that you shouldn't be engaging in blanket bans, which would be denying anyone with any type of criminal history access to housing that you own or manage, and you shouldn't be looking at arrest records since there isn't any conviction that's tied with just an arrest record. Now, a lot of housing providers do use criminal history as they screen people for their housing, which is absolutely fine. But you should make sure that you're using multiple factors when you're looking at that. So also considering reference checks, credit scores, income, employment, and other factors. And if you are looking at a criminal history, you want to make sure that you're doing a case-by-case analysis to see if there is substantial risk in this person becoming a tenant at your property, considering the recency of any offenses, how severe they were, and any mitigation efforts that this individual has taken since the offense. Any supports they have in place and things they've done to move past that incident. So you would look very differently at someone that committed arson last month versus someone that shoplifted 10 years ago in terms of the risk to your property as well as to other tenants. Something that's been in the news lately is appraisal bias. So this is when appraisers use protected classes and consider protected classes when they're determining the fair market value of a property when someone's looking to buy or sell a property, perhaps do some work on their property, refinance it, take out an additional loan. So what we've seen in the news is that a lot of homebuyers of color have resorted to whitewashing a property in order to receive a fair appraisal. So this would be if a homebuyer of color had received an appraisal that they thought was unfairly low. They would remove family photos, any objects from the home that would give any hints towards their race or ethnicity, and ask a family friend or family member who's white to stand in when an appraiser comes by. And some of these incidences have found that they received much higher appraisals once the appraiser was not aware that there was a homeowner of color that was living there. So in response to these reports, the Biden administration has taken efforts to study issues within the home appraisal industry, and they've done that through the Property Appraisal Valuation Equity Task Force, PAVE, because we love acronyms in fair housing. So if you're interested in learning more about this issue, the task force did release a report and action plans for next steps to address this issue, and you can take a look at that on the PAVE website. Okay, we're going to move on to disability-related housing discrimination next, and that's going to take up a chunk of time. So I wanted to see if there's any questions that anyone has before we jump into that. Anything that wasn't clear as I was talking about these other discriminatory practices. I'll check the chat right here. I'm not seeing anything recently, but please feel free to add anything in the chat if you've got questions. Okay. So why do we spend a lot of time on disability-related housing discrimination? In our last fiscal year at PHRC, we found that disability-related complaints made up over half of our housing complaints that we received. So it's clearly an issue. Individuals with disabilities feel that they're being treated unfairly in their housing. So it's something that we want to spend the time to cover. So we're going to start out by defining what disability is under fair housing laws. So it's defined as a physical or mental impairment that substantially limits one or more of a person's major life activities. So you can see the examples on the screen there. Caring for yourself, walking, seeing, hearing, breathing, learning, working. All of the things that we need to do on a daily basis. So you'll also notice that some of those are going to be pretty immediately observable when you meet someone, but some of those are not. So a housing provider may have a tenant with a disability who needs an accommodation, and they might not know it until an accommodation is requested. But that doesn't mean that the request is any less valid. The Fair Housing Act protects 3 different groups of people when it comes to disability. So it protects those who actually have a disability, those who have a history of having a disability, as well as those who are perceived as having a disability. So why is this important? These individuals are protected from all of the practices that we've discussed so far in terms of discriminatory practices, but they also have the right to request reasonable accommodations and modifications that they need to use and enjoy their housing. Someone doesn't necessarily have to have a disability to be treated differently because someone thinks that they have a disability or knows that they had a disability in the past. So that's why all 3 groups of individuals have protections. Now, there are a couple exemptions that I want to make you aware of. If someone is currently using controlled substances and illegal drugs, they would be exempted from disability-related protection. But that doesn't include someone who is in active recovery. As well, if an individual poses a direct threat to the health and safety of others at the property, they would also be exempted from disability-related protection. And this should be based on documented issues of health and safety, not speculation because of someone's condition. So I've mentioned reasonable modifications and reasonable accommodations. So what's the difference between the two? A reasonable modification is when there's actually a structural change that's made to the premises, whereas a reasonable accommodation is when you're changing the policy, the practices, the rules regarding the property, and both can be needed to accommodate the needs of an individual with a disability. So it is discriminatory for a housing provider to refuse to allow a person with a disability permission to modify and pay for changes that would enable them to use a facility. So if a housing provider is a recipient of federal funds, then they are required to pay for the modification, assuming that it's reasonable. It would not be the tenant's responsibility to pay. But if it's in the private market, the housing provider doesn't receive any federal funds, then it's the tenant's responsibility to pay for that modification, not the landlord. The landlord or the housing provider would simply need to give permission or authorization for the tenant to make that change. A housing provider may require the renter to restore the interior to the original condition at the end of tenancy, minus the normal wear and tear, depending on the nature of the modification that's made. A lot of tenants with disabilities are on fixed incomes. So if a tenant requests a modification that's needed, there are services and programs that are out there that can help them to finance or even get a grant to make these modifications if that's something that's needed. So an example of a modification would be installing grab bars in the bathroom, a wheelchair ramp to allow someone access to the building or to a part of the building. Could be lowering countertops, installing a strobe light. There's any number of modifications that could be needed, and they would be based on the nature of what the tenant needs due to their disability. It's also discriminatory for a housing provider to refuse to make reasonable accommodations in the rules and practices that are necessary for an individual with a disability to be able to use and enjoy their housing. So some examples of this would be not allowing a person who's receiving disability income that receives their income on a specific date after rent is due that month. A housing provider would need to allow them to be able to pay their rent on a different date than other tenants to avoid those extra late charges. One that we see a lot is people with disabilities requesting to have a service animal or an emotional support animal. Even if there's a no pet policy in place, if a person would provide appropriate documentation, the housing provider would need to allow them to have that animal that's needed for them to use and enjoy their housing. And we're going to talk about that in a little more detail, since this is usually the question, the point of the part of the presentation when I get a lot of questions. Since service and emotional support animals, there's a lot of misconceptions around what they do, what their function is, and where they're allowed to go. So we're gonna cover that. But it's important to know that it's not a choice. It's a right and a necessity for a lot of individuals to have this support animal. And under the Pennsylvania Human Relations Act, it is unlawful to discriminate against individuals who use these support or guide animals because of their disability. We're going to start off by defining them, since there's a lot of different terminology that's thrown around. A service animal is generally trained in order to perform a specific task. So generally, they support someone with a physical disability that may or may not be obvious. So some examples include pulling a wheelchair, providing mobility support, guiding an individual that has vision impairments, even detecting and alerting individuals of oncoming seizures. So these animals are typically dogs. Support animals, often known as emotional support animals or ESAs, they may not have any special training, but they instead serve a function for an individual with a disability. This could be a physical disability. This could be a mental disability. This could include alleviating someone's anxiety, reducing their depression, keeping them calm, making them feel safe. So oftentimes there's a little bit more stigma around mental disabilities, around ESAs, and the roles that these animals play and function for individuals, but they help people manage conditions that are often not seen and are not obvious to an outside observer. These animals can be any type of common household animal. Could be a dog, a cat, a fish, a gerbil, anything that would be commonly kept as a pet in a household. The only exception to that would be if an individual would need a more unusual animal that would perform a specific task. So the example that HUD gives is a capuchin monkey. If an individual needed help unscrewing medication in order to access their medication. A dog or a cat doesn't have opposable thumbs, so they wouldn't be able to perform that task. But a capuchin monkey would be able to do that since they have those opposable thumbs. So that's a good thing to keep in mind if someone needs a very specific task that could only be accommodated by a different type of animal. So when we're talking about these service and support animals, there's no certification or licensure that's required. These animals do not need to have special vests, special tags, and there's this whole industry that's grown up around emotional support animals that make people believe that you need special tags and certificates and things in order for this to be valid. Unfortunately, these companies take advantage of individuals with disabilities by asking for their money instead of having individuals go through the appropriate route, which would be talking to their doctor and getting a letter from a provider that is aware of their condition and can speak to their need for the animal. So a couple of years ago, there was the Assistance in Service Animal Integrity Act that was passed in an attempt by the Pennsylvania legislature to cut down on some fraud within the industry. So an individual could be held liable if they are knowingly and fraudulently representing an animal as a service or emotional support animal when they are actually not a service or emotional support animal. So if someone's making a reasonable accommodation or modification request, could be for an emotional support animal, could be for another needed change, there's some things that should be held in mind. So this request can be made at any point in the tenancy. It does not have to happen at the very beginning as you're touring the unit or as you're signing a lease. It can happen after move-in. It can happen 3 years after you moved in. It can happen the month before someone moves out. There's no specific timeline on when someone discovers a need because of their disability or becomes disabled. So a housing provider should be prepared to process and accommodate these requests at any point in the tenancy. We always recommend that requests be made in writing, but they can be made verbally as well. We recommend that they're made in writing just so that that someone has documentation and evidence that they did provide this request to their housing provider. But fair housing protections ensure that even if someone calls in or speaks to the housing provider face-to-face, those requests must be treated equally as seriously. This request needs to both be reasonable and it needs to be necessary for the tenant to be able to use and enjoy the property. And the housing provider has the responsibility to treat tenants who are making these requests fairly and to respond in a timely manner, not delaying and asking for unneeded documentation to stall for providing these requests. So when a housing provider is presented with a request, they should establish two criteria. Does the person seeking the accommodation fall under a protected class of disability? So if that is evident, if it's immediately observable that this individual has a disability, there shouldn't be any additional documentation that's requested. And secondly, is there a disability-related need for the accommodation? So is there a nexus between the disability and the request that they are requesting? If that's immediately observable as well, no documentation should be requested and the request should be promptly granted. If there is any documentation needed to establish either of these criteria, then that documentation can be requested from the housing provider, and the tenant would need to turn in this information before the request is granted. There are many housing providers that choose to utilize a reasonable accommodation or modification form, and that's absolutely fine. It standardizes information that's collected, and it allows a housing provider to provide written information about the process that they have in place to process these requests. A lot of times I get asked for sample forms, and the Housing Equality Center of Pennsylvania, which is a nonprofit fair housing organization, has a sample form in one of their guides, which I've linked there and which will get sent out after this presentation. However, there's a couple things that housing providers should keep in mind with these request forms. I mentioned a minute ago that verbal requests must be honored as well. So that means that a housing provider cannot require that a tenant fill out a form or refuse to grant the request until this form is filled out. And a housing provider should make sure that they're not requesting any kind of privileged medical information in their form. That housing provider should never be asking that of their tenant. As I mentioned earlier, a housing provider can ask for proof of need if the disability is not immediately observable. This can be a note from a primary doctor, but it doesn't have to be from a primary physician. It could be from a nurse. It could be from a therapist. It could be from an optometrist, from a licensed social worker, any kind of professional that has knowledge of the individual with a disability and has knowledge of their need can go ahead and write this note. Recommend that it's put on the letterhead of the organization or of the practice. And have information about the letter writer's credentials to be providing this information. But HUD also establishes that alternative documentation that establishes disability for the purpose of a reasonable accommodation request can also include determination of disability from a governmental agency. It can include a receipt of disability benefits or services, and it can also include documentation about eligibility for housing assistance because of a disability. All of these would reasonably establish disability and can be provided. All right, a housing provider should not ask a tenant the nature and severity of their disability, any questions that would lead the tenant to disclose any kind of privileged medical information. They may not ask to see medical records or ask questions about if a tenant is able to live independently. This is information that a housing provider does not need to make this determination. They only need information that would certify that this individual has a disability and disability-related need for the request. All right, but a housing provider can make a denial in a couple different situations. So if the disability and disability-related need are not immediately observable, a housing provider requests documentation and the individual does not provide it, then a denial can be made. If a request poses a direct threat to the health and safety of others, a denial can be made. So this has to be based on documented evidence. It can't be speculative about what a housing provider believes might be a danger. Possibly, it has to be, you know, this animal has a history of biting other tenants. You know, that would be a direct threat to the health and safety of others. But it can't be speculative, say, because of a breed of animals that that a housing provider believes might be aggressive. And a housing provider can deny the individual's request if this request would cause substantial physical damage to the property. That would be another reason for denial. The housing provider can require that all individuals with animals follow state and local regulations, including licensing and vaccinations that are required for any animals at the property, pets or service animals, ESAs. If the animal's conduct is violating the rules of the housing provider, a housing provider can issue violations and require the individual with the disability to bring the animal under control. The animal is considered to be an extension of the individual with disabilities. So it's as if the tenant themselves are violating the rules of the housing provider. And lastly, a housing provider can hold a tenant responsible if this animal is causing physical damage to the housing property. Then the housing provider can go ahead and take that damage beyond normal wear and tear out of a security deposit or charge the tenant for any additional damage to the property should that occur. They can't charge any upfront fees, deposits, pet rent, things like that, since that would be different terms and conditions for individuals with disabilities, but they can hold a tenant responsible for those damages. All right. A housing provider cannot put limits on breeds or impose weight limits on assistance animals. Even if they have these weight limits and breed restrictions for pets, they do need to be waived for assistance animals. And a housing provider should be very cautious if they're citing insurance policy cost increases as an undue burden and a reason for denying the request. So we often see this with certain breeds of animals. A housing provider might say, oh, we can't get this covered under our policy. It'll be a significant increase, and this is an undue burden and a reason that we can't grant this request. Insurance providers are required to comply with fair housing laws as well. So a housing provider should make sure that they are informing the insurance provider in writing that this is in response to a reasonable accommodation request that they're seeking to accommodate. If the insurance provider still insists on the increased rates, I would encourage the housing provider to do their due diligence in seeking out alternative insurance providers, working with their broker to see if how they can accommodate this individual without an undue cost before issuing a denial. And a housing provider cannot pass along additional expenses, such as charging extra fees, rents, or security deposits, as I just mentioned. All right, so that brings us to the end of assistance animals. Are there any questions on this topic before I move on to a couple other reasonable accommodation requests? Seeing the chat is pretty quiet. Everyone's still awake? Give me a thumbs up if you're still with me. Or raise your hand. All right. Awesome. Thanks for providing that feedback. I appreciate it. All right, let's talk about hoarding. So hoarding can be a fair housing issue that you may encounter as a reasonable accommodation request. So hoarding is listed as a mental disorder in the DSM-5, and it's when someone acquires a lot of possessions in their home. The items might be worthless, they're often hazardous or unsanitary, lead to pests, insects, other issues, leads to clutter around the home, an inability to use areas of the unit, access key electrical panels, other health and safety issues can impede an ability to exit the home. So all of these can be of concerns to housing providers. Now, not every dirty home is a hoarding situation, as most folks would recognize. Simple clutter doesn't necessarily mean that it's a hoarding situation, but when there's substantial amounts of belongings that make whole sections of the house unlivable and the tenant unable to navigate that, then it can become a severe issue of concern. So a helpful resource in understanding the various levels and types of hoarding can be the Institute for Challenging Disorganization. They've got a clutter hoarding scale, which talks about how hoarding can impact structure and zoning, the potential for animals and pests, impeding household functions, health and safety, and any kind of PPE that would be needed to use to address the situation, as well as different levels. So I've got the link on there and you can check that out at your convenience. But oftentimes, as is obvious, the housing provider would need to address this issue for health and safety for the tenant themselves, as well as for safety of the property and safety of other tenants in the property. So the landlord can enforce the lease provisions, which often include about care of the home, and it would be on the tenant to ask for assistance and reasonable accommodations in that process. We encourage the housing provider to set very clear expectations about what's needed for both parties. So what needs to be done, what needs to be prioritized, and what does non-compliance look like? So what's the timeline? What has to happen first to make sure the property is safe to live in? And what happens next? And at that point, the tenant or other supports that the tenant have can request perhaps additional time, an ability to focus on a specific area, to bring in outside supports to be able to address this issue. If a tenant does have family members, perhaps a social service provider, a case manager, a supports coordinator, someone that can help them work through this process, we encourage the housing provider to invite the tenant to bring them into that conversation, so that way they can help the tenant work through this issue. And as any of you who have worked with hoarding know, this is not going to be something that's going to be fixed next week. It will often take time to address this issue and patience, both in in terms of the tenant and the housing provider, and must be an interactive dialogue to be able to help resolve this issue. So that way the landlord's property is kept safely and the tenant is able to live safely and maintain their housing. And then the last reasonable accommodation that I want to touch on is parking accommodations. So we know that a lot of apartment complexes already have designated handicap parking spaces because of accessibility requirements. But there could be a situation in which a tenant with a disability that doesn't meet their needs. They may not be able to reserve that parking spot and have it available when they need it. It may not be close enough to their unit or provide the needed access. So if a tenant has these additional needs, the housing provider is required to make a reasonable accommodation so that way this tenant can meet their housing needs. If a housing provider is in this situation, we encourage them to ask a tenant specifically what's needed. Where is this parking needed? Does it simply need to be reserved? Do they need to have extra van access to be able to exit their vehicle safely? So if this request is made, and if the tenant provides any needed supporting documentation, the housing provider is required to accommodate and to engage in a conversation with this tenant about how to meet those parking needs. Courts have found that housing providers are responsible for the costs that might be associated with making this accommodation. It could be in restriping the lot, installing a sign, something like that. Those costs should not be passed along to the tenant. So a housing provider should have an established policy. They should make sure that they're documenting everything in response to a reasonable accommodation or modification request in writing. And they should make sure that they're limiting the information that they're requesting to the bare minimum of what is needed to process the request. They should allow sufficient time for documentation to be submitted and respond back within a timely manner. So HUD guidance states within 10 days is reasonable. And they should engage in interactive dialogue to meet the needs of a tenant. If you are working with a tenant who needs a reasonable accommodation and is running into barriers, I encourage you to reach out to a fair housing organization. You can reach out to PHRC for information, as well as there are numerous private fair housing organizations throughout the state that can assist individuals with making these requests and navigating the process. All right, so that's the end of the section on discriminatory acts. It was clearly the bulk of this presentation. I'd invite you to take a quick minute just to provide some feedback. Out of the things that we've discussed so far today, what are things that you've seen in your community in terms of discrimination against a specific protected class or a specific practice that I've covered that you've come up against? I'm curious to see what the feedback is. And I'll give just a moment to see if there are any responses there. We're coming down to the home stretch. We're going to cover the complaint process in just a minute, and I'll be providing some follow-up resources as well as a survey link for today's presentation. All right, I am not seeing any responses in the chat. But I assume you all are processing information. If you have anything that you want to provide as feedback, please feel free to respond in the chat as you're able. All right, thanks, Betsy. Requesting rent on the first day of the month, even though the check doesn't come as fast. Yep, that's definitely a reasonable accommodation request that should be made and should be granted. Okay, so what happens if someone believes they've been a victim of housing discrimination? How do they move forward? So if they're in Pennsylvania, we encourage them to reach out to the Human Relations Commission to get some information. They can get a paper questionnaire. They can go onto our website to start the filing process online, and they can give us a call. We find that the most helpful way to get folks through the process the quickest is to set them up with an appointment with an intake investigator, which can happen either via video chat or on the phone right now. So that way, that intake specialist can walk them through the process. The intake specialist would need to assess for timeliness and jurisdiction. The complainant would be interviewed. The complaint would be drafted and sent to the complainant, which is the person that's filing the complaint. So that way they can sign it and verify that all of that information is correct before moving forward. Once that signed complaint is received back by PHRC, the case moves forward. If a signed complaint is not received, or if the complaint isn't timely or jurisdictional, then the case would not move forward. Once that complaint is filed, then it gets docketed and served. It would get served to the respondent, and which is the person the complaint is filed against. That respondent would need to answer to it, and then the investigation begins. So it's important that folks know that when a complaint is filed, the intake staff, the investigators, they're all completely neutral throughout the process until there's probable cause that's established. If there's probable cause that's established. So an investigator is not on the side of either the complainant or the respondent. Their role is to find out what happened. So sometimes this can get established through a fact-finding conference where both parties get together. Sometimes there's a settlement that gets established before the cause of or before a probable cause is established. If that's not the case, the investigation continues until there's a finding. If no probable cause is established, that doesn't necessarily mean that discrimination didn't occur. It just means that there isn't enough evidence to pursue a finding of discrimination. And an individual does have the ability to appeal if they do not agree with that result. If probable cause is found, that means that there is enough evidence to establish that discrimination did occur. And from then, there's either conciliation that would lead to a settlement, or it could advance to a public hearing, in which case it would either go before the courts or before an administrative law judge. So as you can see, it's a bit of an involved process. It can take some time. So the process can take up to a year or even more, depending on the nature and complexity of the case, as well as the quickness of the responses from both the complainant and the respondent, and their willingness to negotiate. To give you an idea of the complaints that we receive, as I mentioned earlier, disability is one of the top complaints that we do receive in housing, as well as our other subject areas as well. In housing, it's followed up by race and color, and then third would be retaliation for filing a fair housing complaint. What are the remedies that can be received for a housing case? You can see listed on there. There's any number of things that can be granted through a fair housing complaint. They could be given the ability to rent the property, stop an eviction, make the needed accommodations. There could be policy changes that are required for the housing provider. Could be that there are fees that are reimbursed, or or forgiven. Civil penalties. The housing provider may need to post fair housing notices. The respondent often needs to complete training, and if there's out-of-pocket expenses that were accrued throughout this process, then the respondent can need to pay those. In the center, though, you'll see that money for humiliation and embarrassment is highlighted. That's because this is unique to housing cases. All of these other remedies can be obtained throughout all of our subject areas, but it's only in housing cases that money for humiliation and embarrassment can be granted to the complainant. And you can see that housing awards can get pretty high. You'll see here 1.5 million for a housing provider that didn't provide accessible units, ignored requests for reasonable accommodations, sexual harassment, racial harassment, refusal to grant reasonable accommodation. So there's a number of awards, and these are a little bit older, but these cases do result in action, and there's a whole bunch of settlements that are private that we can't even reveal because it was a private settlement. But filing a complaint can lead to substantive action. So we do encourage community members, if you believe that you've been a victim of housing discrimination, that you do file a complaint so that it can be investigated and addressed. So next month, we'll be talking about affirmatively furthering fair housing with Adrian Garcia. He's the Director of Fair Housing and Commercial Properties. So as part of this subject area, we're going to build on the information that we covered today. We'll be discussing the history of housing segregation and inequality in the U.S., how we got to where we are today, why fair housing laws actually came into place, and the tools that our fair housing laws provide to affirmatively further fair housing. I know you're in a variety of roles that are joining us on the call today. I saw that in your comments in the chat. So there's a variety of ways that you can use partnerships to further your efforts and address fair housing issues in your communities, and we'll provide some resources for you to learn more about that. So I encourage you all to register and attend for the session on July 27th as well. I'll be sending this out, the links to more fair housing information that you can pursue when you've got some time, brochures that you can give out, you can request from us, as well as some more detailed guidance from HUD, Department of Justice, from PHRC that can support your fair housing work. And of course, I want to provide my contact information as well. So you've got the address of the central office, our main phone number. This is me. You can contact me at my email here. If you've got a specific fair housing question, you can also call our fair housing line and get connected to a fair housing expert who can help you answer a question if you're running into a tough issue. I'm also asking that you take a second to fill out this this training feedback form. So I think there's 10 questions, it takes like 2 minutes to fill out, but it gives us some valuable feedback on this training and on what you've found valuable. So with that, I am going to end my slideshow. I'm going to get that link so that way I can put it in the chat for you all. So you can take a minute while you're on this call to fill that out. And I'm going to take a look at the chat to see what questions you've got. Okay, I see a question. If a tenant calls another tenant a name and they call us about it, what should we do? So you want to make sure that you're documenting that that incident, and you investigate and see if you can get to the bottom of it. See if there's any corroborating witnesses that can back up what the tenant says. So that way you can address it if it's against your, if it's racial, sexual harassment based on any protected classes. That's something that you want to make sure is not happening in your community. But if you have more detailed questions on that, you can feel free to reach out to me. Betsy, great question on where the fair housing officer fits into this process. So as a fair housing officer, you want to be providing this information throughout the community. We have a number of fair housing officers that are a part of our Affirmatively Furthering Fair Housing Task Force. So I'd be happy to send you information on that if you're interested, where we talk about strategies that different counties and areas engage in to increase knowledge of fair housing. We know that not everyone is fully aware of their rights and how to go about that process. So a fair housing officer is a pretty key role in providing that information and helping to connect folks to resources, particularly if you don't have a private fair housing agency in your area. All right, and I see there is a comment for our fair housing ads. We include a phone number for HUD in relationship to the process. Should we provide PHRC instead or along with? Yes, I would absolutely encourage you to include PHRC's number as well. That way folks can reach out to us. And if they are interested in getting started in the complaint process, they can either call our main central number, or they can call our fair housing number. And either one is absolutely going to get them to the right intake folks to get them started and answer any questions that they have. All right, so if you have any other questions, please feel free to put them in the chat, email me afterwards, reach out as any fair housing issues come up. At PHRC, we're here as a resource for everyone involved in the housing process, and I would much rather help guide you and provide correct information to help you get through fair housing issues than have anyone be contacted by our investigative staff. Want to make sure that folks are equipped with all of the right information that they need. And I want to thank you for all of your attention today. Thanks for bearing with the technical issues at the beginning, and thanks for all your feedback. And I guess now I will turn it back over to David.
Thank you, Brittany. That was a great presentation, and we will be sending out the presentation afterwards. And just a reminder that this was recorded, so we'll also be posting the recording of the training as soon as we get it processed. Thank you again for attending. Again, my apologies for the technical difficulties in the beginning. But again, Brittany, great job and great presentation.